We will hear argument this morning in Case 24-1238, Montgomery versus Caribe Transport. Mr. Clement.
Mr. Chief Justice, and may it please the Court. When Congress ended federal economic regulation of the transportation industry, it did not want states to fill the deregulatory gap with economic regulation of their own. It thus enacted a preemption clause modeled on the Airline Deregulation Act that preempts state laws related to prices, routes, or services of motor carriers or brokers with respect to the transportation of property. But while Congress favored economic deregulation, the last thing it wanted was safety deregulation. To that end, it preserved federal safety regulatory authority, and it accepted state safety regulatory authority with respect to motor vehicles. My friends concede that state tort law is a classic exercise of regulatory authority and that a principal aim of tort law is safety. Thus, the question in this case boils down to whether the negligent hiring claim here is with respect to motor vehicles. Of course it is. The whole point of the tort is to keep dangerous motor vehicles off of the road. Indeed, my friends concede as much when the tort is directed at a carrier. But that essentially gives away the game, because it's the same tort whether it's directed at a carrier or a broker, and it is no less with respect to motor vehicles when it's directed against a broker who may well know that the vehicles are poorly maintained, or the carrier is underinsured, or not registered with the federal government at all. Nonetheless, my friends would immunize the brokers in all those situations. That cannot be squared with the plain text or with common sense. Indeed, my friends have to insert words into the statute, like direct linked or direct connection, that are absent from the statutory text. This court should interpret the statute as written and not let the brokers off scot-free. I welcome the court's questions.
Mr. Clement, what did the landscape look like before deregulations? And by that I mean, who was responsible for the safety regulations? Was it the ICC or some other federal agency, or was it the state?
So it was both the Federal Transportation Department or subparts of the Federal Transportation Department at the federal level and the states at the state level. So the old ICC regulated rates, prices, and routes, but it did not regulate safety. And that's really the regime I think Congress—
Well, I'm more interested in the safety aspect, because I think much of what we're talking about will depend on what it means to regulate the safety of motor vehicles, including the operation. So I'm interested if you would detail the safety regime before the ICC was deregulated.
So before the ICC was deregulated—
Was eliminated, I'm sorry.
Yeah, eliminated, right. You did have some federal safety regulation from the federal government, but not through the ICC, through the Transportation Department. But you also had, and there was no preemption of it, you also had state safety regulation. And they could take many forms. They could be positive law regulations that go to safety, everything from speed limits to other provisions, weight limits, maintenance requirements. But you also had these state negligent hiring torts that were applied under the old regime, both against carriers and against brokers. And we cite the L.B. Foster case, for example, from the Ninth Circuit in 1969 in our brief. And that's a state negligent hiring claim that was brought against both brokers and against carriers, and the Ninth Circuit upheld it. And of course, there would have been no basis before 1995 to even argue that claim against a broker was preempted, and no argument before 1994 that claim was preempted against a carrier.
One oddity, I think, that you have to deal with is that your theory would mean that claims against brokers would be preempted for intra-state transportation, but not for interstate transportation, which seems a bit backwards in terms of preemption. And that's something, if you think the question here is how broadly to read with respect to motor vehicles, and you're thinking about context and common sense, which you mentioned, that seems to be in tension with that. You want to respond to that?
I would love to, because I think there is a counterintuitiveness to the fact that Congress seems to have provided a broader preemption provision for interstate routes, prices, and services for brokers and freight forwarders, and a smaller preemptive scope for interstate. Now, that anomaly is going to exist no matter how you decide this case, because B is broader not just because it doesn't have a safety exception, but also because it doesn't have the phrase with respect to the transportation of property. So, so like a case like Dan City, where this court said that with respect to the transportation of property is what meant there was no preemption, there would be preemption for interstate. Now, I'm not here to tell you that makes any sense. But what I am here to tell you is that Congress in 1995 made a very deliberate decision to treat brokers and freight forwarders differently for interstate and for intrastate. I mean, it would have been the easiest thing in the world in 1995, because remember, brokers are added to both a year after the principal statute. It would have been the easiest thing in the world to create like a subsection that was about brokers and freight forwarders for interstate and intrastate. But Congress didn't do that. They consciously had a separate sub-B clause for intrastate, and then they consciously dropped the brokers and the freight forwarders into C, which already had the safety exception.
Just going back to the real world, though, a broker in Los Angeles who arranges a trip to San Francisco, no tort suits available. But if it's to Reno, a tort suit is available under your theory, right?
Under our theory of the safety exception. Now, you might
on
be
the safety exception,
right,
which is the key. And I guess I'm still trying to figure out how that makes some sense, particularly when, let's just add to it, the other kind of issue that bothers me a little bit here is the fact that Congress required financial security requirements for the truckers, but not for the brokers, and with respect to accidents. And that seems another thing that you can respond to.
Sure, but let me respond to them in turn. So starting just to reiterate what I said with B, I mean, look, I'm not here to tell you that that's not a little bit anomalous, but it would be more anomalous to take two statutes, one of which has a safety exception and one of which doesn't, and interpret them to mean the same thing. And there's no question that B is not the applicable provision here. C is the applicable provision. And as I said, no matter what you do with the safety exception, you're going to still have an intrastate provision that has broader preemptive force than the interstate provision, because B doesn't have that with respect to transportation.
What about the financial security requirement? If we're trying to figure out what Congress was doing, which I think you've talked about here in 94 and 95, they say that the truckers the trucking companies have to have financial security so they can pay judgments with respect to accidents, but they don't do that on brokers. And when you combine the two things we're talking about, that's in tension with your position, but what's your best response to that?
Well, I think I have several pretty good responses to that. I mean, one of which is it's even more complicated than that, because freight forwarders were also supposed to have some insurance against injury risk. So you can't make some idea that everybody in the sub B is different from everybody in the sub C, if you're following me on that. But more to the point,
I am, but if Congress envisioned tort suits against brokers, why not require brokers to have the insurance to pay the judgments?
Because I think Congress rationally said we want to make sure that they have a financial security requirement that is responsive to the principal financial risk that they face. And it's different with respect to carriers than with respect to brokers. The principal financial security risk that brokers have is default. But you can't read too much into the insurance requirements, because nobody thinks that carriers can't default. In fact, carriers are defaulting all the time and going bankrupt all the time. And so you can't draw too strong an inference. And what I would also say is there's also sort of an asymmetry in the inference that you would draw. Because, some lower courts, for example, have focused on that insurance requirement by finding that safety torts are not preempted in the Airline Deregulatory Act context. But that sort of makes sense, because it would be very weird for Congress to force a carrier to insure against a risk that is actually zero because the risk is preempted. So when Congress says you must insure against something, it's actually a pretty positive sign that there's not preemption. But I don't think it works the other way around. There's all sorts of contexts where you say things are not preempted, and Congress hasn't even thought to make somebody insure against it. So I just don't think, I don't think there is a presumption against preemption in the express preemption context, but boy, you need something more than an insurance requirement to ignore the plain text of a clause that is designed to deal with the issue of preemption straight up.
Can I take you back, Mr. Clement, to Justice Kavanaugh's first set of questions, the interstate, and you said you're not here to tell us that it makes any sense. Do you have a theory whether or not it makes any sense about how it came to be? I mean, why?
I think that, it was a different Congress a year later. Maybe the interest groups lobbied a little different a year later. Maybe the same people weren't paying attention a year later. And again, though, I think the critical thing, though, is the one thing we can't ignore is that Congress made the deliberate judgment to treat interstate and intrastate differently. Now, if you really think they should be the same, then maybe that's a reason to not read the preemption clause to reach safety-related torts altogether, as lower courts have read the ADA. I mean, if the anomaly is really bothering you, that's the one way you can make the anomaly go away. Or I actually suppose, like the text of B is a little bit different, and it's so focused on intrastate rates, intrastate routes, intrastate services, that you could say that really, unless you're talking specifically about intrastate services, the preemption clause doesn't apply. But maybe it's best to leave all of that for a case that actually implicates B, because this is a C case. And Congress clearly said, with respect to interstate, at the moment it's creating this new exception for intrastate, brokers and freight forwarders. At the same moment, it says, what we're going to do? We're going to not treat brokers and freight forwarders the same way for interstate and intrastate. And when it comes to interstate, we're going to drop them into a preemption provision that has a safety exception. I think that's what you have to sort of try to interpret here. And then if you get to the safety exception, I think the question of whether these negligent hiring torts against a broker are with respect to motor vehicles is quite straightforward. And I think if you understand the nature of the 411 restatement tort, the whole reason that there is a negligent hiring tort in certain circumstances but not others is because you're hiring somebody to do something that has the possibility of harm, bodily harm to third persons rather. And what creates the threat of bodily harm to third persons in this context? It's the 80,000-pound motor vehicle that you're putting somebody behind the wheel of or you're entrusting the cargo to. And that's true whether it's a tort against the broker or against the carrier. And so if I hire somebody to just paint my house and they do a lousy job, shame on me, but there's no negligent hiring of a contractor tort in that context because just painting the house isn't going to pose a risk of bodily harm to third parties. So what really triggers this whole tort is a risk of bodily harm to third parties. And the only thing in this mix that poses that risk of bodily harm to third parties is the motor vehicle. So if you follow what tort we're talking about here, it really does make the connection to motor vehicles quite direct.
Mr. Clement, could another way of thinking about this really be focusing on C, as you've encouraged us to do, and how it operates, what it's doing? It seems to me that one could conceive of this as C1, Congress coming in and making a change to the status quo. This is the deregulation point that you said. And they say in that section that this deregulation is occurring with respect to the economic aspects of the system. And then the safety clause, this part that we're all focused on now, is really just clarifying to some extent that what they have done with respect to preemption is leaving the status quo regarding safety. And so Justice Thomas's point was a good one. In other words, what was the status quo? States were regulating with respect to safety. So
one word of that, I would say that's exactly how the lower courts have approached this in the context of the ADA, where you don't have a safety exception, so your eyes don't immediately go to the safety exception. But still, courts have realized that long before, in the bad old days of federal economic regulation, you still had state tort suits for personal injury and the rest. And so when Congress in the ADA says, all right, we want to get rid of the federal economic regulation, and we don't want the states replacing it with new economic regulation of their own, but they had no interest whatsoever in getting rid of all those tort actions. And as we say in the briefs, but I think it's quite true, actually from Congress's perspective, if you want economic deregulation, the last thing you want is a huge uptick in accidents and lots of safety mishaps.
Can I just interrupt there, and just on the rhetoric? It's not getting rid of safety tort suits. The tort suits against the trucking companies, the carriers, are still preserved. Everyone agrees on that.
Sure, but the problem is once you agree to that, there's really no coherent reason to stop there. You're looking at the state tort, and the state tort is not
I was just responding to your point about safety regulation being gone. No, safety regulation through tort suits still exists. Everyone agrees against the primary people who are going to be sued, as I think you've acknowledged, which are the truckers, the carriers.
Yeah, and I didn't mean to get carried away with my rhetoric. My point was just if you're a rational deregulator, but all you care about, you've Chicago school, you want economic freedom. The last thing you want at that same moment is for there to be new safety problems.
And my point was why would we think that, given the background that you're talking about, that Congress would be focused on preserving only the tort claims with respect to the truckers as opposed to the brokers, as opposed to anybody else? In other words, why Congress's attention, it would seem to me, would not be at the level of who is actually going to ultimately be sued, under tort in these different states or whatnot. The point of its regulation was just to say we are concerned with economic deregulation. Those who are regulating safety carry on. And under whatever state's law, if they have a particular tort, if they had it before, if it's operating, then Congress wasn't bothering that. If it applied to brokers as well as truckers, Congress wasn't bothering that. It just seems odd to me to think that we would read this statute and all that it's doing to have Congress caring about the particular defendants who are going to be sued at the end of the day.
Again, I couldn't agree more, and I think if you look at that L.B. Foster case, 1969 Ninth Circuit case, that's a case where the plaintiff sued the shipper, the broker, and the carrier. And under California law, they were all liable. Now, some other state might make a judgment that we want to stop liability at the broker and not have it go to the shipper. Or another state might say we want to stop liability at the carrier. Maybe a state, I think it would be crazy, but maybe a state wants to stop it at the driver. All of those are judgments that the states get to make, and I don't think, as you suggested—
So even if a shipper uses a broker who then hires a motor carrier, you think the shipper is included in this?
I do. I think in a sense that's a much more straightforward case. As long as the state tort reaches them, then the shippers aren't covered by the preemption clause. And I don't think the shippers have much of an argument. You got to start with the argument that it's preempted and then resist the safety exception. So the shippers can't get to first base because they're not covered by the preemption clause. And one of the anomalies that the other side's position creates, they like to talk about the brokers as just being middlemen or middle persons, but they're middlemen between shippers and carriers who both, at least in some states, are liable for this negligent hiring tort. So it's weird to have the middleman between two people that are potentially liable immune, and if you allow that to happen, it creates a huge artificial incentive for shippers to use brokers, because that's a way they can try to download, and the other thing they can do is they can actually reinvent themselves as brokers.
As far as, I'm sorry.
Oh, no, I'm sorry.
Yeah, as far as federal law is concerned, how far does with respect to motor vehicles extend? This is a classic question of causation. Does it extend to anything that could contribute to an accident?
So I'm not sure that it, sort of goes to, the butterfly effect and all of that kind of thing. What this court has said in lots of contexts is it doesn't have to be super direct. There's no direct link requirement, but at the same time, things that are attenuated, peripheral, and remote, I think is the phrase this court has used on a couple of occasions, are not covered. Now here, I think it's a pretty easy way to say that this is not wildly indirect for purposes.
Yeah, no, I see that. But do you think there is some limitation in this phrase with respect to?
Absolutely. But I would say, if I were sitting on Congress's shoulder and saying, all right, we want direct connections only, I would say don't use the with respect to language.
And the limitation is proximate cause under state law. Is that the limitation?
Well, that's one practical limitation in this context because you can't bring the tort against a broker under state law unless you satisfy the proximate cause requirement.
Yeah, well, I understand this is pretty direct, but if something has to be, some kind of directness requirement or a minimum link requirement has to be read into C2, then I come back to the question that Justice Kavanaugh led up with, which is the real anomaly, which is very hard to accept, that there's preemption for intrastate activity, but not for interstate activity. And I came to the argument hoping you were going to give us some brilliant way of reconciling these two provisions, other than just live with it. But I guess there is no such theory.
If there is, it has escaped me. But as I say, I do think it's telling that you are going to have a broader intrastate preemption clause no matter how you decide this case. The other thing is, I would say, I don't think, I mean, that would really be letting the tail wag the dog. You know, I've looked through all these cases. I think there are 2 intrastate cases that I've been able to find. Maybe my friends have found more. But there are, dozens and dozens of interstate cases. And the intrastate cases I found have actually said there's no preemption on sort of the ADA. That's not what this is all about. So I think it would be a mistake to let the absence of the safety exception in B be the tail that wags the dog.
What do you do with the fact that the brokers, I think the amicus brief of the Transportation Intermediaries Association, particularly pages 20 to 24, really go in detail of if tort liability extends to them, how are they going to assess and evaluate the safety of drivers in a particular trucking company? How are they going to figure out, do they have an alcohol drug issue? How are they going to figure out English proficiency, which of course is a critical issue at the current moment that's being discussed? How are they going to do this is the real concern that's raised in that brief and by respondents that I think is something you need to respond to.
Sure, I'll try to respond to it, and I think it may be much more straightforward than you think in many cases. I mean, ultimately, like, the legal answer is it's the know or should have known standard. But
usually when you say that, sorry to interrupt, there's some way for the tortfeasor to protect themselves, and what they're saying here is in the real world of how brokers operate, it's very difficult.
So I think it's going to be pretty easy for them to protect themselves by hiring quality carriers.
And that's going to favor so this whole thing's going to really favor the large established carriers over the smaller carriers because they're going to default to that to protect themselves, I think, which is fine, but I just wanted the implications of your position to be understood.
Look, you can be a safe small carrier, and here's the thing, and
they tend not to be as safe as the larger ones, correct?
Well, some of them tend to be very unsafe, and some of them tend to be these chameleon carriers where their safety record is terrible, and then they show back up. And the situations where there should be liability is when the broker knows, or should know, that it's a chameleon carrier. If they've just been dealing with this carrier as, Joe's Trucking, run by Joe Smith, and then all of a sudden Joe Smith shows up, and this time it's Smith Trucking, the carrier's going to know that, the broker's going to know that. And here's one of the things that sort of helped me understand all of this, which is you have a number of situations where there is a captive carrier, where that carrier does only loads for C.H. Robinson. And so in that circumstance, C.H. Robinson is going to know every bit as much as the carrier is going to know in those circumstances. Now, there are going to be other situations, like say, they can protect themselves, but they can also protect themselves by asking some questions and having some screens. I mean, this is a case where C.H. Robinson's own policy says that they don't hire carriers that have conditional safety ratings, but they did it here anyways. So, so you have cases like that where, yeah, you can worry a little bit about how they're going to protect themselves, but they already take some efforts. And when they blow their own sort of standards, or like...
Well, they were relying on the federal government standards because the federal government regulates the trucking companies and kind of certifies them. That's probably not good enough, is what you're saying, which I don't disagree. I'm not taking issue with that, but that's what they've been relying on in the past, right?
But the federal government regulates in a very minimal way, and the federal statute specifically says it's a minimum, not a maximum, and states are free to go above that. And, I mean, you really can't underestimate...
And for the carriers, that begs the question, but keep going. Yeah.
I mean, the statistics that the amicus briefs have shown is that roughly 94% of carriers have not had, a safety exam by the federal government. And the way this works is to get on the road in the first instance, you do not have to go through it's kind of less rigorous than getting your state driver's license for a car. So.
Thank you, counsel. Justice Thomas, any further?
Would you take a minute and walk me through why you think, or why it's agreed here that subsection 2 regulates safety in intrastate cases?
So, the argument would be that, you know, if this were a B case, and I was trying to argue that safety is not preempted, what I would do is I would make an argument sort of like I would make in the airline deregulation context, which is to say there were these tort claims beforehand. They probably, like, the last thing anybody would have thought was going to be preempted beforehand was an intrastate tort claim. And all Congress was trying to do with B is to make sure when they deregulate interstate that there aren't these sort of confusing intrastate regulations of the same economic things. So that would basically be my argument. I could warm to it and try to get a little more textual and try to say that, you know, it's written a little bit differently, and it really does focus on intrastate rates, intrastate routes, intrastate services of any freight forwarder or broker. And it's just a little hard to think of these, like, negligent hiring things as being sort of like distinctly intrastate. But it's a harder case than C. I'll grant you that.
Was there ever any federal involvement during the ICC era with intrastate shipping?
No, that was, I mean, except in one or two areas where they felt like they had to do it to rationally regulate interstate. But under the old ICC, the basic division of labor was interstate federal, intrastate state.
So why would this have any application at all, just structurally, to intrastate shipping? If the deregulatory effort is to deregulate covered areas, and this area was not intrastate, why would it have any application at all?
Oh, I'm surmising now, but I think the idea was, okay, like in a world where everything's regulated at the federal level, it's pretty easy to sort of hand off like regulation to the states when it's intrastate. But in a world where you really want the free markets to sort of prevail, having this little island of state economic regulation of intrastate starts to seem like less wholesome, and it's sort of interfering with the federal objectives. And in this regard, it's probably worth recognizing, you know, the federal deregulation takes place in 1980. They don't impose the preemption provision generally until 94, and then they don't address brokers and freight forwarders till 1995. So for 15 years, the federal government was perfectly happy to deregulate at the federal level and let the states kind of do what they want. And then at a certain point, I'm surmising that they said some of the state regulation is getting in the way of our federal economic deregulatory objectives. But at the same time, you know, the one place, well, in the two places, because they did it for passenger too, they really did try to preserve state regulatory authority with respect to safety in motor vehicles.
Justice Alito? Justice Sotomayor?
I paused when I was reading the briefs in this case. Is the intrastate preemption subject to challenge? Because if it's been decoupled from interstate commerce, under what congressional power could the government preempt?
I'm guessing. I mean, it's probably a pretty good question for the federal government. If I had to make the argument for them, I would say that it's under the necessary and proper clause, and it would be under the theory that they needed to regulate the intrastate in order to rationally deregulate the interstate. But I guess I'll take the question as a friendly amendment as just one more reason to leave the intrastate provision for a case where it's actually at issue. Because the one thing that's crystal clear here is they have no B argument. This is interstate. And so,
yes, and I do understand what you're saying to Justice Kavanaugh and Alito, which is the difference between intrastate and interstate is even wider than whether you cover brokers or not. Because intrastate, they're preempting everything, not just whether it's in transport of property.
right. And, you know, like if I were going to warm to the topic of having to have a theory of how all this works, I suppose if what they were really trying to do in 1995 is make sure that the state regulation sort of doesn't interfere, maybe they just address it a little bit differently.
Could I stop you to go back on the shipper question? Because one of my questions in my mind was, how far back can you go? Could you go to the shipper and you're saying in many states you can, would that be for hiring a negligent carrier or for hiring a negligent driver?
So
Meaning, is the liability automatic for the shipper?
So under certain circumstances, and I think the most circumstances, it would be for hiring a negligent carrier. But I think it also could get to the driver level. I mean, I think, in a case like this, and this happens more frequently than you think. I mean, I think one of the other statistics in the amicus brief is some 50% of all carriers only have one driver. So particularly if you're a broker, you may very well know not just what carrier you're getting, but what driver you're getting.
But your point is that the shipper would not be preempted under any circumstance. So this lawsuit doesn't have a defense under this act if you're suing the shipper.
If you're suing the shipper, that's right. Now, there is an amicus brief here that's, or two actually, I think, on behalf of shippers that are making what I think is kind of an extravagant argument that they are covered by the preemption provision, even though it obviously doesn't address shippers and it only addresses carriers, brokers, and freight.
Do you happen to know if there are lawsuits against shippers that go on routinely?
My understanding is that there are, but my understanding is that, it's also caused some shippers to start using brokers because
it's a way to
at least
try
it gives
to
you
avoid.
a colorable textual preemption argument to use a broker.
Thank you.
Justice Kagan?
Mr. Clement, the government has an argument, I think it's the government, might be the respondents too, that your theory makes this with respect to motor vehicles phrase superfluous. I was just wondering what you would say about that.
I was hoping you would ask. So I think there's a big problem with that argument because I think it sort of fails to appreciate how broad the definition of transportation is. And the statutory definition of transportation that's relevant for this part of the statute is reproduced at pages 18 and 19 of the petition, if you have that. But it's incredibly broad definition, and it's 23A. And the first thing in the definition is a motor vehicle. And then it then goes on to list 10 other things: vessel, warehouse, wharf, pier, dock, yard, property, facility, instrumentality, or equipment of any kind. And then there's a B clause that goes on and talks about services related to movement, including receipt, delivery, elevation. I had to look that one up and figured out they're actually talking about grain elevators. Transfer in transit, refrigeration, icing, ventilation, storage, handling, packaging, unpackaging, and interchange of passengers. So there is an enormous amount of things that come within the broad definition of transportation that do not involve motor vehicles. So there is no superfluity problem here at all. And I would say that the breadth of that definition of transportation is maybe one more reason to think that maybe you should decide this case either just on the safety exception, or maybe you should say the preemption clause doesn't apply here at all to safety torts, a la the lower court handling of the ADA cases. Because if somebody gets injured on a wharf or a pier or a dock, there's no way that's with respect to a motor vehicle, or it could certainly not be. And it'd be pretty weird if that were preempted. But of course, the old ICC had a pretty broad sense of what it got to regulate, including the routes and charges and services for like a grain elevator. So I do think there are real reasons for caution here, but I'm glad you asked the question because I do think the more you appreciate the breadth of the statutory definition of transportation, the less persuaded you would be by that superfluity argument.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
If you prevail here, I just want to pick up on what brokers will need to do. So you prevail here, then you're counsel to a broker, say, and the broker is worried about the issue the Wall Street Journal focused on yesterday, the English language proficiency of drivers who can't read signs, okay? And so the broker says, I don't want to select a carrier that hires drivers that are not proficient in English language. How do they do that? And do they need to do that? And how do they do that? Because that's a lot of the current discussion is, there are a lot of different issues, but that's one that's currently in the current events.
So complicated question. I'd probably give them a pretty long memo. And, I'd start by saying I'm not sure these English language requirements are really sort of safety regulations with respect to motor vehicles. And maybe they are. But I think that's a debatable question sort of at the threshold.
Well, why not? If you can't read, if you're hiring drivers who can't read the signs, that seems like a safety issue.
If you say so. I
assume that's true.
Okay, assume that's true. Then I got to I want to address whether I'm violating some other federal